Good evening, chat. Hello, and I apologize. Before we finish saying hellos, I gotta get back to this. So give me 1 second. I'll be right back. I gotta get back to this. You can find this at potentiallycriminal.com/sandwich. I mean, this is better than DSP playing, isn't it? Look at this shit. Just Clyde's up there. Bam! Bam! Look, I don't even have to move and it's just happening for me. Look at this chat. We're getting there. We're getting there. Oh, yeah. This is tough. This is actually really tough because the screen is so wide. I have to move so far. It's a lot easier on the phone. Get it. Come on. We can do this. We can do this, chat. We're grooving. Wow, some of this stuff's falling faster now. I mean, we're moving fast. Uh-oh. Ooh. All right, we're going to keep going. We're level 3. Pace is picking up. We're going. Oh, that's too far away. We can't keep up, chat. There's too much. It's too Boku. Oh, no. Uh-oh. There we go. We're getting there. We're getting there, chat. We're getting there. All right, let's keep going. Level 4. Okay, this is getting really fast now. I can't. There's too much. We're done. There's too much falling. Sorry, chat. There's too much falling. I couldn't keep up. But let's see what this is. Got to click on it, and you can always go to my page on the farms. Oh, it was tough. Imagine playing this at court. Yes. Yes, there's a bonus. There's the bonus round is the Haitians. And chat, once again, you guys could find that at you can find that potentiallycriminal.com/sandwich. You can help Clyde stack them up and do his job, make sandwiches for me. Just keep at it. Guys, made by Maddie B. Once again, Maddie, thank you very much for that. That is hilarious. And yeah. We'll do a whole gamer marathon stream of that. Just that for 8 hours. Watch, I get everybody playing this and somebody finally does make it to the end of the game. Yeah. But it's a lot easier on the phone because the level is only this wide, so you can catch everything. Oh, it's uppercase. Oh, all right. It's got to be uppercase. All right. I'll fix it. But yes, thank you, Maddie. There. Sandwich. So. Yeah, so you can get the highest score. I know. You can see you get the highest score out there. So, guys, thank you again so much. Maddie, thank you for that, man. I appreciate it. And just thank all you guys in general. I truly appreciate all this stuff. A lot of fun. And even though Maddie's a Janny, very, very cool thing. Oh, looking to turn me into Homestar Runner. There's nothing wrong with Homestar Wanna. Yes, or you can click on Clyde on the homepage. Yes. If you go to the homepage here, I still feel like this is false advertising because I am not that skinny. But anyways, if you guys come on down to the bottom here to the bloggers and you click on Chef Clyde, it brings you to the brings you to this game here if you click on Chef Clyde. So that is how you find it. The only thing I remember from Remembers is Trogdor the Burninator. No, I remember Homesar. I was raised by a cup of coffee. Pashoo! I remember all of it. The Cheat, Marzipan, everybody. Yes. Also, Teen Girl Squad. Yes. Mm-hmm. Mm-hmm. The website is linked in the description, Samuel. It is. If you guys go down below, I took out my firm website, and since that's attached, and you guys could find it there. So, if you cared to read, you didn't even notice. You didn't even read my description, but yes, it's down there. All right. Real quick, we got a couple things here. Unhung Hero for 10 subs. Starting the night off strong. EDW Raptor for 10 more subs. Oh, guys, we are getting ready to go tonight. Here we go. That's right. We got 2 of them. That's right. It's just ready to go. EDW Raptor says, happy birthday, Sean. Well, thank you. Once again, it's not my birthday till the 10th, but we're getting there. August 1st, guys. So welcome to the show. Welcome to the show. I'm Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area. And tonight we're going to talk about Russell Greer. A bunch went down in this past week since we were talking about Russell Greer. And then there are some big updates in the Ethan Kline versus Frogan and Denham's case. Casey Tron's involved in this, but nobody really cares about her. So, but anyways, real quick, I got to open this up from 2.0. She had something for me to open up tonight, so we'll see what this is. It's too small for a bomb. What is this? What? Beard oil? Babe, are you saying something? Does my beard smell? From who? Oh. Well, you guys want me to use beard oil? I always thought beard oil was just what you guys would say, like, quietly, like, when you're rubbing in, like, another man's jizz in your beard at the truck stop. But I guess beard oil really is a thing. I thought it was, like, gay man code, but okay. There's all kinds of, like, flavors or scents here. There's, like, Aruba, like a sampler. There's no goo scented one, I guess, so, there's no Minnesota Madness. Oud Madeira. Madeira. Rich mahogany. Sounds very, very bullish. So we'll have to try this. Anyways, I got from Warlord Beard Oil. So apparently you guys suggested that to 2.0. So I guess I'll try it. Never been a big. This isn't beard oil. This is just it grows. It grows. And like I said, one day I'm just gonna come on and it's gonna be shaved and I'll just ignore it. I'll pretend like nothing happened for 3-4 weeks, and I'll be like, "What do you guys mean it's being shaved? Look, it's long again." There's no Jamaican bull jam, no. If I have dry skin in my beard, it's good for that. I actually don't. I don't have a problem with it. It's just if this gets too long, I sometimes I could feel it, or like when it starts growing in, like I can get like a week or so in with growth and then I don't feel it. But then like that second week and third week, I just feel it and it drives me crazy. So yes, popular scent Worski's pajamas. No. How have you had a beard for so long and never heard of beard oil? Like, I didn't really think it was a real thing. I thought it was like a joke. Like, why do you need to oil your beard? Like, I wash it every day. Like, you're washing your hair and you wash it. Like, there's not a whole lot to it. See, Stony sauce. Oh, that's good. That is good. That is perfect. Oh. So it's called grooming. I mean, I don't know. And then Franklin T. Esquire says it's oddly specific. Sean, that was oddly specific. I mean, hey, what can I say? What can I say? Jeff always used beard oil. Well, if it was good enough for Jeff, it's good enough for me. I definitely can try it. Let's see. There's so much Sean still doesn't know. I mean, like, I always thought it was just like hipster bullshit. Because you'd see like the things for beard oil, and it's the people who have like all the goofy, like they wax their beards and stuff. I guess I don't know. Still use Johnson and Johnson still. I mean, well, I use like Head and Shoulders, and that's what I just know. I mean, I don't even put product in this. This is just I shower and I get out and I comb it, and this is how it looks during the day. I don't use product at all. So I'm very simple. I'm very low maintenance. You feed me a sandwich, and it's kind of like that's all I need. All I need. All right, guys, it is time to get started. It is time to get started on this. On here it says, buy a beard for your beard, chat. Yes. Speaking of that, Mr. Medicare, apparently Kirsha says that Jim is still alive. We'll find out. We'll find out if Foxu is lying to us. Is Foxu a glowy? Is she truly part of the, Zionist conspiracy out there? Is she part of Zog? Is she an agent of the Zionist occupation government? Maybe. Because other people have said Jim is dead. We'll find out. Someone's telling the truth. Place your bets, gentlemen. Place your bets. Jade wouldn't make a big statement if it were true. I mean, unless she killed him. Maybe she just looked at Jim and was like, too much cringe now. And she just, like, one flew over the cuckoo's nest and just suffocated him. All right. Yes. Well, we had HH die. We had OO die. Maybe MM as well. Yes. Oh. Oh, David is saying the Stabby versus Jones has come to a dismissal agreement. Possible question if this moots the sanctions the courts want to impose. Stabby said, no. Nope. The court can still impose any sanction it wants to because he was disciplined for conduct the court is upset about. So if you misconduct, this is actually good. This is something I think we talked about this before, chat. I think this came up when we were covering some of the Trump stuff. So, for example, I think it was with one of the cases where we're trying to afuera somebody, and by afuera, kick him out of America. If you are sanctioned by the court, dismissing a case does not end the sanctions. Far from it. All that means left is the court's ability to issue sanctions. Now, if these are sanctions that would have affected the outcome of a case, well, yeah, the court doesn't really have much of an option. But if you were acting in misconduct before the court, and the court sua sponte on its own wanted to impose sanctions, it could still punish you. It can give you monetary fines. It can force you to have to attach a sanction reprimand to documents. It can, refer you to discipline. I mean, there's a lot of things the court can still do that even after your case is over. You don't automatically get to go like neener, it's over, judge. No, you don't get to do that. It does not work that way. If it worked that way, so many attorneys who have gotten in trouble over the years, especially ones now using AI, would just go, oh, we're dismissing, done. Fuck you, judge. We're out. No, you can't do that. If the court wants to sanction you, the court will sanction you. It retains that authority, it retains that power. It 100% retains that power, and it doesn't lose the authority or jurisdiction simply because the case ended. That is a very good. I know you're not asking the question, but Stabby Acerthorn is doing that question. Yeah, Acerthorn, that doesn't work that way. The court could still sanction you for your misconduct. So they ain't going to forget about you. They're going to vexatious litigate your ass. They are going to punish you for your fucking scumbaggery. So, yeah, couldn't happen to a nicer guy. All right, guys. Now, moving on from there, we are going to start off with We'll get into the Ethan Kline and Frogan and Denham's lawsuits. Like I said, Casey Tron's involved, but she's not doing anything retarded right now. The real issues right now are kind of interesting for what's going on. And this is just going to be kind of recapping some things here. Now, remember, Ethan Kline, through his company, TED Entertainment, is suing Frogan, Denham's, and Casey Tron. And he's suing them for copyright infringement. He's also suing the mods and the H3 Snark subreddit for contributory copyright infringement. Now, it's different claims for the mods versus the streamers. And remember, Frogan, Casey Tron, and Denham's are streamers. They're bread tubers. You can call them tankies, whatever you want to. But they are streamers, and they are politically, they're all going the same direction. They're fellow travelers, but Ethan Kline is not a tanky. And they don't like him because Ethan Kline doesn't get along with Hassan. And Frogan's, Denham, and Casey Tron, well, they're Hassan orbiters now. So they streamed the content nuke, and they did it with the intent to deprive Ethan Kline of the ability to gain revenue, gain clicks, and do it to frustrate his abilities. Well, Ethan Kline sued them. And one of the big things we talked about last was that Denham's had agreed to allow Ethan Kline to subpoena Reddit for the information of the H3 Snark mods. And because these Reddit mods are, thinking Reddit was going to protect them, I doubt they are. And they weren't sure that this order was going to go through or that it had been granted yet. Well, remember, Ethan and Denham's had agreed to this. Courts don't get in the way. If parties make a stipulation, courts aren't going to get in the way of that. Because who are we? Who am I to get in the way of what the two parties in front of me agree to? The court is not in charge of that. The court is just a referee and makes sure the case shepherds along. He can't say, no, that's not an acceptable agreement. He can't say, I will not accept your stipulation. I mean, there are times that might happen, but when it comes to discovery, oh no, he's going to allow these parties to go do what they want. And what do we have? We have from the Central District of California, which is where LI is, we have the order. And this order is to grant the joint stipulation allowing the plaintiff to serve third-party subpoenas prior to the Rule 26F conference. Remember, Rule 26F is the discovery rule in the rules of civil procedure, and they are just asking to do that ahead of time. Typically, you cannot do that before you sit down and confer with the other party. So Ethan has to sit down with Denham's. Obviously, their attorneys would do this. They would sit down and they would set up, are we going to have depositions? What's our schedule going to be like? Our timeline for handing over documents? If we have objections, you lay that all out the best you can. And that's how you do this. That's the 26F conference. You're not supposed to do any discovery, and serving subpoenas is discovery. You're not supposed to do that until then. Well, Ethan wants to get ahead of this and get going. Well, Denham's like, fine, sure. And it says the court says upon consideration of the joint stipulation and for good cause shown, and that is always upon information and for good cause shown. That is almost found in every single court order you will ever find in America. They're just saying, upon consideration and information and for good cause shown, that shows the court is making this on good cause. I am issuing this order. The stipulation is granted. TED Entertainment Incorporated may serve the subpoena attached to Reddit. And then TEI may also serve Discord. If you are one of the H3 Snark mods, oh, buddy, I told you. Remember, we went through this with the one Redditor, Roman P, or Roman V, or whoever the hell he was. I don't care. He's like, oh, it's not going to happen. It hasn't happened yet. It was going to happen. And now that it's happened, what's your cope? I can't wait to see the cope. It's coming. And it's like a No Country for Old Men. You can't stop what's coming. You can't. You can't stop what's coming. Reddit is not going to get in the way of a copyright lawsuit. Reddit can't afford that. So, good luck. Good luck out there, mods. You Reddit Jannies. Good luck, man. And yes, it's funny. All the online experts said the judge would 100% reject it. Yeah. Why would the judge reject it? The parties are agreeing to it. Less problems for him to worry about. Life is good now. The judge could go play golf. So, yes. Godspeed, Jannies. Godspeed. And as we move on, we're now moving into the lawsuit versus Frogan. Now, the Frogan and Denham's and Casey Tron lawsuit are all basically the same. We're not going to review all of them. I know some people out there have reviewed all of them. They're basically the same. There are some facts that, Ethan lays out how cringe and retarded each one of them are individually. Just take my word for it. Denham's retarded. Denham's retarded. Frogan retarded. Casey Tron retarded. They're in there. You guys can read all these, but we don't need. It's assumed. We'll just assume they're retarded, okay? We'll just assume they're retarded. Now, from here, with that said, there was a complaint filed and a lawsuit filed against Frogan. And once again, this is another one of these 80-page, 64-page monster things out there. We're not going to read through all of it, but it just gives you an idea of, we're doing this so you understand what we're looking at here. Because ultimately, and hold on, did that pop up? There we go. Ultimately, this was filed the same time frame. And what happened? Well, this is filed against TEI, Ted Entertainment Incorporated, versus Morgan Kamal Majid, also known as Frogan. And that's Frogan's. Remember, you have to sue them by their legal name, but you include them as Frogan. And then the Does 1 through 10, the Reddit mods. So this is, yes, Frogan reacting by exiting. And yes, this is the stuff. This right here will fuck her. Time to watch the nuke ethically. Hell yeah. Well, there we go. There's Frogan getting up. And if you guys don't know who Frogan is, she's kind of like, she was the one who did the whole, I hope all the soldiers get PTSD. Based. And this is her just acting like a complete little turd monster. She hangs off Hassan's nutsack. And we don't really know what she does. But this is her. This is Frogan. This is her. Cringe incarnate. So that is Frogan. If you've never seen her before, she is a tanky. She is a hardcore lefty. She can go out of the helicopter like everybody else can. She allegedly, she has a master's in public health or something like that. I don't really know what she has. Who knows? But anyway, Frogan was sued. And this is her lawsuit here. And the issue now for Frogan is, what are we doing with this? Like, what happened with Frogan's lawsuit? So it was filed 6/19, but that doesn't mean anything. What matters the most is service. So this right here, chat, is critical. This is a notice and proof of service and of the summons and the complaint. Because remember, just because you file a lawsuit doesn't mean anything. You have to serve the other party. They have to be served. If they haven't been served, nothing can happen. Now, let's say you can't find them. That's one thing. After a while, yes, you have to use a process server or somebody appointed as one to personally serve the party. If that service were to fail, there are things you can do. There are alternative methods of service, but you have to exhaust those methods of service. And at the federal level, it's even more strict. At the state levels, you can kind of do things differently. But there are rules of service that are governed, and they're governed in the Federal Rules of Civil Procedure. Well, the first and primary way is service personally, and you hire a process server. So what do we have here? This is the proof of service of the summons and complaint. And here what we have. At the time of the service, I was at least 18 years old. This is the process server doing this. So the process server, you have to be 18 years of age and not a party to this action. So it can be really any adult. Now, what does that mean? Well, as a lawyer, I can't technically go out and serve people. I can't serve the opposing party. That's not proper. I can serve subpoenas on anybody I want to. But if I want to serve a lawsuit on someone and a complaint, I need to get a process server. Or there are times where if I have a client and he's got a relative who can go do it, you can get away with that at times. There are times where before I've used, depending on which locality I'm in, there is, some counties I practice in, there's a guy who's done PI work for me. He's a former sheriff's deputy. And he's, as long as it's in the county, he gives me like a dirt cheap rate on service. And he's got a body cam and he shows up and serves people. And he's really good at finding people. He's really good at being low key. And this is where you get all that stuff that you see on like Suits, where somebody shows up carrying the pizzas or the bag of Chinese food and says, "Hey, I have an order for, Mike Ross. Is this you?" "Yep, you've been served." Like, you can do that. If you guys have seen Pineapple Express, you can be deceptive to affect service. You can't impersonate the police or the fire department, but you could show up as FedEx. Like, "Hey, I've, here's a box for you. Oh, you've been served." Like, there are things you can do. So there are rules, but they're not a ton of rules for process serving. So what did they serve with her? Well, they served on Frogan a complaint, and then it says see attached document list. The person who was served, the defendant, Morgan Kamal Majid, also known as Frogan or Majed. I don't know. I don't really care if I pronounce it right. It doesn't matter. I don't care. I won't be able to hear it over the sound of the helicopter. The address for the papers were served, 430 South Broadway, Los Angeles, California. Manner of service, in accordance with the Federal Rules of Civil Procedure, which are different than the California Code of Civil Procedure. There's differences. And he served the person by personal service is one of them. You personally did it. Okay. Or substitute service. What does that mean? Well, it was done by Jane Doe, who was an occupant. I don't know what the fuck her name was, but it was some African-American or Middle Eastern woman. She was female, in her 40s, 5'6", 155 pounds, dark, long, curly hair, dark eyes. Now, while there's a physical description on here, very likely, and I hope to, like, if Ethan Kline can afford it, you use a process server. I mean, I do when I can as much as possible. You're dictated by your client's money, though. You use a process server who has a body cam on, because that's going to get saved. And from there, if it comes to court and Frogan's like, "I never got this," they'll be like, "Yeah, who the hell is this?" They're in your house. They're in your apartment. So that's why, like, body cams are important. So where do they serve at? At her home. Now, you can serve at somebody's business, but, it's always easier to go to their home because they can't say I didn't get, well, no, that's at your house. The papers were served on July 14th, 2025 at 6:12 p.m. And you're allowed to serve outside of business hours. In fact, I mean, most people are at work during the day. But yes, process servers could strike at any time. They could strike at any time. KRS says, can they use a body cam in a private residence? They don't have to go in. They merely just go, and you open the door and say, "Hi, I have stuff here for Morgan." "Okay, well, here, can you give this to her?" "Yeah, cool, thank you." And, yeah, there you go. I'll give that to her. Don't worry about it. There are times where you can do that. So that's all it takes. Like, the guy doesn't barge into her house. Like, the process server cannot break into your home, but he can do that. Yeah. Actresses, people have been served at award ceremonies. Yeah. Yep. Access, could a server serve you on federal property? I don't know about that. That's actually, I don't know the answer to that question. But anyways, this was a good question, KRS, but I hope you understand that this isn't an idea of them going in the house, but it's going to be the door opens and you can see what's inside the doorway. So now from there, the papers were mailed on July 15th, and there's a declaration of mailing. So not only did they serve her in person, they mailed them. Okay. And then there's due diligence. I made at least 3 attempts to personally serve the defendant. And that's part of what has to happen. You have to try to serve the person a couple of times. And that's how it works when you hire a process server. They say, look, you get 3 attempts. Tell me what time, what is a person's schedule, and you get as much information from them as they can. And they try to work on this, and they come up with a game plan real quick. And they may have different people, like a lot of process servers. It'll be a guy running the company, and he might have like women that work for him too. And it's a woman come knocking on the door, holding the clipboard, like, "Hi, I'm here. Like, would you like to fill out a survey?" "Yes, I'm just making sure. Is this the right address?" "Yeah." "Are you so and so?" "Yep." Boom, served. If you guys have ever watched Yellowstone, when Jamie comes out the door with the shotgun to that guy, and the guy just keeps on like, "Hey, is John Dutton here? Is John Dutton here?" That's how process servers are. So if you're ever like stuff like that happens, don't, I would say don't tell them who you are, because once you identify yourself, served. Now, here's how that went. This is what gets filled out. Um, it was done by First Legal Investigations. So this is obviously, and you're in LA, so you have resources like this where service process serving organizations. This is very common. They probably also do private eye work. And once again, they talk about what they did. And there's just more of this here. And you see they got their little logo here. And they talk about all the stuff they did. The person that served was a guy named Jason Luther. And he is a registered California process server. In some states, you have to be registered. And they go through all of this. Now, sometimes you might be a California, you might be a sheriff, marshal, or constable, and it's different. Sometimes the sheriff's department will serve legal paperwork. And this guy served that, and he signed it saying this is true. Now, he is declaring under the penalty of perjury this is true. So if he fucks around, he's in trouble. So that was served on Frogan. And then they tried a couple different times. Here, okay? And this is the declaration of diligence. Then this is, once again, this is definitely something you need in federal court. This is very well detailed. And it shows you on July 1st, I tried at 2:30 a.m. Yeah, you guys might say, wait, what? 2:30 in the morning? Yes. 2:30 in the morning. But that's what a $2,500 fee does. Also, it's like a couple $100 out here, but you're paying LA prices. How's that fee compared to what I've paid? Not that much at all. But yeah, when is she going to be up? And it says it's a 5-story apartment style building that's secured by a locked door and intercom. Now, some of you might just read like, how do I break in? The subject's not listed on the list. No one was seen outside. I could not gain access. I decided to wait until it was able to gain access by someone letting me in. This is how they do it. They are allowed to get, hey man, I know Morgan. She lives up on the 3rd floor. Sorry, I tried to get a hold of her. Can you let me in? Yeah, sure. Come on in, buddy. At 3:15, I was able to gain access by following a resident or guest as they were leaving the building. You see how this works? Some of you guys might say, that's fucked up. That's how it works. Said, I located where number 403 is. I could stand down the hallway and be able to stay out of the way of you and be able to watch the unit without being too inconspicuous. At 4:30 a.m., nobody left or entered the unit. I stepped away and left the location without being noticed. No activity, left at 4:30 a.m. Now, some of you might say, well, that seems like he was testing it out. Yeah. He went and you have to do intelligence gathering. You're doing a route survey. He's getting ready to do a hit. He's got to go study the target. He talks about the next day at 2:30 a.m. He was not able to get access The doors were locked at 3:05. I was able to gain access by entering as a resident or guest left. And he kept on going. He kept on going. I maintained my position down the hall from 3:15 until 6:30. During this time, there were no changes. No one was seen entering or exiting. The doors remained closed. I quietly locked up the door and listened for any movement. I did not hear anything. I did not knock on the door. Instead, I just took note of the findings. Some of you might say this is a little insane, but this is how it works. This is how it works. Now, someone said, can you pick locks? No. You cannot commit a crime to serve someone. It's not a crime if somebody lets you into the building, but you are not allowed to forcibly enter a property. If you have to pick locks to enter an apartment building, you're in deep shit. You're not allowed to do that. Yes, never allow tailgaters into a building. That's personal security 101. But also help out the people where you live. But yeah, don't ever there. So Mr. Tim Beatty saying 2:30 a.m. doesn't like due diligence. He's gaining route intelligence, more or less. And also, I'm sure that he notices like Frogan's probably streaming at 2:30 in the morning or something like that too. At the very least. So you just keep going here, and it just keeps going. He talks more. On 7-5, he showed up a couple of times. He sat there. I was far enough away where I would be seen from maybe looking at people. He was there from 2:15 till 8 a.m. I made an attempt where I walked up to the door and I knocked on the door and placed a document on the ground saying delivery and stuff to wait. Yeah, and no one came out to pick up the documents. And then finally, we get to the 14th when he actually did it. Now, at 2:12 p.m., I was able to gain access. That's why he goes at 2 o'clock in the morning, because nobody's seeing him. And he understands the layout of the building and how he gets in there. This is due diligence, professional work. I entered after a resident was leaving with his dog. I approached Unit 403, and I could hear a female voice talking. I cannot tell what was being said, but it sounds like someone was giving their point of view. I stepped away and positioned myself there. At 6:12, I heard the doorknob of 403 make noise, and the door quickly opened. Stepping out was a darker female in her 40s, 5'6", 155, long curly hair with dark eyes. I asked her if she's Morgan, and she said, why? I said, I have legal documents for you. She said she's not Morgan. I asked her if Morgan lived there, and she said no. She has lived there for 6 years, and there's no Morgan. I asked her if she would show ID, showing she's not Morgan, and she refused. I told her since she won't show her ID that I'll be serving her, and she refused to take the documents, so I placed them in front of her on the door, in front of her door on the ground. The female saw me place them there. She said, I'm not Morgan. You can speak to the management. Now, here's the issue. That's service. But is that Frogan? That doesn't sound like Frogan. She knew she was caught, but is that Frogan? Because Frogan's not in her 40s. Frogan is younger. And also, as they talk about long curly hair, Frogan's always wearing a hijab. So you can't tell what she's wearing. Brendan says this is literally the worst court server era. Yeah. Also, 155 pounds seems a bit light. I agree. Frogan's not 155. As a fat guy, I can tell you when somebody's fat and she's fat. So we don't know exactly who this is. He has a picture, yes. He has pictures. He has body cam footage. Now, here's the issue. So we think Frogan's been served. Now, at this point, it was served on the 14th. 21 days from then, and what do we know now? Well, when you've been served, okay, a defendant, and this is the rules of civil procedure, this is Federal Rule 12. When you do this, you have 21 days. A defendant must serve an answer within 21 days of being served the summons or complaint. Or if you timely waive service. But we're not dealing with that because she hasn't waived service. But what we do have is 21 days of being served with a summons and complaint. All right. Well, what's 21 days from July 14th? And you might laugh at this, guys, but this is how you count the days. July 14th, add 21 days. August 4th, 2025. Now, here's where it gets to the idea that it does sound like Frogan has been served. All right. There's a couple of things that tell us that. And one of the biggest things here, and we're going to get to this, no, keep moving on here. Frogan has 21 days to respond. Now, she said she's getting an attorney. An attorney could show up on August 4th and say, hey, look, I've been retained. I need to file a motion. I need a continuance. I need an extension to enlarge my time to file on this case. Yeah, that can happen. That could happen. She could have an attorney ready to go. Do I think it's going to happen? Probably not. You don't like doing that anyway. You don't want to show up on the day of as a new attorney because you might get told no. Now, here's the issue. This is a brand new lawsuit. So the court's generally going to be pretty considerate of that. And this is where, once again, I know Destiny got really mad when I said I didn't think he had an attorney because the days were just ticking by and he didn't have anybody showing up. Yes, as time goes by, where are your attorney? If you don't have an attorney, where are they? What's going on? And nothing's been happening. That becomes an issue. Like, there's all kinds of problems that happen here at this point. This is this is an issue. This is an issue. Like, what do you do? What do you do from here? Well, hopefully she does have an attorney. If not, she has to respond to the court as a pro se litigant by Monday. Now, she could ask for more time herself, and the court will probably grant it. But she's got to do something pretty fucking quick. Now, the only thing that may save her is if she, on Monday, mails something. If she mails something, she has the mailbox rule. It counts. She gets 3 days. The mail gets to the courthouse. It's still good to go. And they read it, and it's been filed properly the date it gets mailed. I doubt Frogan's, I don't know what Frogan's going to do, but she better fucking figure it out quick. Because if Monday passes and nothing happens, and even then Ethan and his attorneys, there'll be a couple days, once again, the mailbox rules. Nothing happens. They will then move for what's called default, a default judgment. And this is Rule 55 of the Federal Rules of Civil Procedure. And it's default, a default judgment. And they talk about entering a default. And the default is because Frogan has not responded. Remember, when you get your complaint, you are warned you have to respond. If you don't respond, well, you're going to have problems because when you are given your documents, you are told you have to respond. And if you don't, that is a problem for all the parties involved. Because now they've got to do stuff. Well, if you don't respond, Ethan could say, well, look, I win. And he's going to be able to say that. If Frogan does not respond, he will win here. And he gets to walk into court and he gets to say, Your Honor, the other party hasn't shown up. I'm entitled to a default judgment if they're not going to appear and defend their case. And the court will say, yes, the requisite time has passed. I will enter a default for you. Now, there are two types of defaults you can get. You can get the clerk to enter a default. Now, if the plaintiff's claim is for a sum certain or a sum that can be made certain by computation, The clerk on the plaintiff's request with an affidavit showing the amount due must enter judgment on that amount and for cost against the defendant who has defaulted or is not appearing and who is neither a minor nor an incompetent person. Well, that's not really what we're looking at here because it's all copyright infringement. We don't have we don't have those damages sorted out yet. So in all other cases, it's going to be by the court. The party must apply to the court for a default judgment. A default judgment may be entered against a minor or incompetent person only if represented. They say if the party against whom a default judgment is sought has appeared personally or by a representative, that party must be served with a written notice of the application 7 days before the hearing. And at that point, the court has to conduct a hearing. And Ethan and his attorneys will sit there and they have to explain what happens. And then from there, the judge has to conduct the hearing. And what is it? When they enter a judgment, it needs to conduct an accounting. They have to determine the amount of damages. Ethan and his attorneys are going to have to provide evidence. You still have to provide evidence. You can't just go, Your Honor, well, here's our complaint. No, the judge is going to say, well, counsel put on evidence. Ethan Kline will get up. How do we count this? You may have to investigate a matter. You may have to investigate it. There may be more stuff. It's not as simple as, show up, get default, simple as. It's generally not that bad, but you're going to have to do the work. And Ethan and them are going to have the work prepared. That's not really an issue. Now, just because the default gets entered, it's not over all the way. You can set aside a default judgment. Okay? The court can set aside an entry of default for good cause, and it may set aside a final default under Rule 60B. Now, why are there ways you can do a setting aside of a default? One of the biggest ones is, for example, is saying, I never got service. I was never served. Now, some of you might say, well, Frogan knows the lawsuit is out there. Yeah, so what? I know it's out there. If you can't, you're suing me. Okay, great. I don't have to tell you where I'm at. It's your job to serve me. It's not my job to make service for you. You're not put on constructive notice of the lawsuit like that. There are times where that may happen. This is not one of them. She isn't going to be able to say that. Now, there are things that do hurt Frogan, and there are things that make it sound like she was served and she is aware. And one of the biggest things that she's going to have is this. And the idea that she doesn't know she's being sued, well, it's going to be a little tougher as this thing right here. Frogan's Lawsuit Defense Fund. And she went on GoFundMe. She's raised over $35,000, which in a federal court case, that's just gone. Now, that's the issue. And what we don't see on here, you guys, is, and this becomes an issue for her, she created it June 20th. So this is created before she got served. But it is the day after Ethan Kline filed his complaint. Okay? So you see June 20th, 2025. You're like, okay. Well, that's the day after Ethan's complaint was filed. Because we go up to the complaint he filed against her, and we go back to this chat, and you can see right here, 6/19. So she does it the day afterwards. So what's going to happen here? There's going to be some issues. Did she actually know what's happening? Can she claim it? I mean, like I said, she can try to claim it. Is that really going to work for her? I don't know. That's going to be very, 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 very tough. I think there's going to be and one of the things that Frogan might be dumb enough to talk about, and I don't know if she has she talked about being served on camera? Because if she knows somebody got served, that's going to be bad. That's going to be bad. There are going to be a lot of problems for her, but there are ways she can contest a default. And it's courts. And now here's the issue for that. Why would a court want to allow default to get overturned? Why do courts allow for that? Well, courts have an investment in making sure issues are litigated. And they want issues to be litigated. They want issues to be sorted out. And why is that important? Why is that important? Um, because we want cases to be resolved. We want them tried. We want them tested. We want the adversarial process to be engaged with. So you can do all kinds of stuff with this, and you're going to have to make an argument. It's going to have to be persuasive. The judge might say, I don't fucking believe you. And if he's like, I don't care, I don't believe you, well, then you're screwed. But this becomes, could she just argue she was expecting to get served preparing just in case it happened? Sure. She's allowed to prepare, but it all depends on what information has been obtained, and we don't know. We don't know what other information's out there. Maybe they have proof. Like, I'm assuming Ethan, like, here's the problem. Ethan and his attorneys are very good. Frogan and Denham's and these guys are all fucking retards. So they may have that information. Now, I would argue they do that. What happens there? I don't know yet. Frogan might have a good way of saying that. Now, this is a where Tiger Ray's bringing up something here. If Frogan does live there, but the roommate doesn't give her the documents, well, at that point, Ethan's going to say, look, we have proof of service. It was served at your home. I think a court may cut her some slack there, but that's going to be a tough case to sell. That is going to be a tough case to sell. So I don't think that'll work for her. That's at the end of the day, it's not going to help. But all she gets at that point is, if the default gets lifted, is the case continues on as though there was no default, and she has to litigate it. So merely doing this doesn't make it go away, doesn't make it better. So as much as she does want to do this, this doesn't make it go away. You don't win. You just merely don't get killed. So it's merely you get to pull your head out of the guillotine. And using a term that her and her fellow, communist tankies will understand as the guillotine. She sounds her patrol. She can self-deport. She is a natural-born U.S. citizen, so just like Hassan, she can't really self-deport because she's where she's from. Yes, they are 39 IQ, yes. If she put up her GoFundMe before Ethan announced it publicly, would that affect things? And well, that's the thing here. When you look, no, but I mean, this happened after Ethan filed the lawsuit. But remember, just because Ethan filed it doesn't mean you have to respond. So very much like we talked about last week with Lolcow LLC and Null, until they've been served by Acerthorn, there is no lawsuit to worry about. They don't have any obligation to respond. So Acerthorn filed a lawsuit over a year ago, and since it hasn't been served, there's no obligation to respond. Frogan has to respond. So that is where we are. And I don't know what's going to happen here, but it should be funny. And in the meantime, Ethan Kline's out there, H3 Productions. That's his Instagram. And he says, Frogan is literally about to default early next week. What has she done with the $50K she raised? Yeah, what did she do with that? Did she commit fraud? I mean, that's another issue for Frogan. Where did all this money go you took from people? The $50K she raised, it's only 35 unless she's, obviously it's 35 here, but maybe she's lying. Also, I do think it's funny. She's only 18% to her goal of 200K. Suffer, Frogan, suffer. And look, she's got monthly simps. It's like, really? You got men simping out over you, but I guess. We have not heard from her attorney at all. She has like 5 days to respond to our complaint if she loses by default. Once again, she can ask for more time. There's a lot of things she can do. So it's not over yet, but it's looking that way. It's looking that way. So we'll see. We'll see. So that's really the Ethan Kline saga right now, and oh, and that's Ethan Kline. That's the whole Ethan Kline Frogan Denham's update, and it looks like Frogan might default. Like I said, if she has an attorney, like where does this guy he appear? Like I double check Pacer real quick. Hold on, I'm checking Pacer. I don't see anything yet. No updates on Pacer, and that's the federal court filing system. Nothing there. Nothing there. So, oh man. Oh man. So David says for Ace since Logcow has appeared in the case, doesn't that harm the fact they haven't been served? Nope. They made an appearance for different reasons. They haven't been served. The 21 days haven't occurred yet. They have not been served yet. They still have to be served properly. But they did not file an answer. They filed challenging his informa paupera status, which you can do. You can make a limited appearance like that. And it's not really a limited appearance, but they kind of short-circuited everything. Where Tiger Ray says, what if that's actually not her making the GoFundMe? What if the troll's committing fraud? No, Denham's has like plugged her GoFundMe. So there's no issue about that. She's plugged it. So that's not really a concern. Yes, the money's going to vanish as it always does under communism. Yes. Is the 50K GoFundMe plus stream subs, bits, and super chats? Nope. That is just GoFundMe. Woo man is the poor man's whoa buddy. Yes. Oy vey. There's also that too. Pessy Man says, did I see another dildo got thrown in the middle of a WNBA game? No, but based. Once again, I'm surprised those basketball players didn't see a rubber dildo and like all dive for it like a jump ball. So there we go. There we go. That's it for them, guys. And now moving on to Russell Greer. There is Russell Greer updates, and a lot's happened in the past week. And as much as it sounded like Russell's kind of hurting and cruising for a bruising, well, not like what we think. Not like what we think. Now, when we left off with Russell Greer, you guys remember he had sought sanctions against Matthew Harden, and we're not going to go through this whole document again, but this was from the 15th, and he was crying that they were stalking him, that they went and found his stuff in Winnemucca. Because remember, Russell Greer had lied about getting a continuance because there was something that he couldn't get to. Well, that's because he went to Winnemucca to go get a whorehouse built. And he testified in front of city council. And we covered that. And Russell Greer had lied about why he needed a continuance. And he held the phone pretrial outside the hallway of the city council room while he was trying to get set up for his whorehouse in Winnemucca, Nevada. So that got filed. As we moved on, more stuff happened. And here is, we didn't get this before it happened here, but Matthew Harden showed up with his motion for opposing Russell Greer's sanctions. And this is document 348. This is in response to 347. Now, I talked to Matthew Harden about this at the time, and I'm like, why don't you just say we tire of this retarded bullshit? And, and Matthew Harden agreed. He's like, I'm going to just be as concise as I have to now. There's no reason. Like, we've already done this before. We no longer need to suffer this stupidity. And, a little more flowery language, but he agreed that we're done. He's like, I'm done screwing around. Now, they are opposing the sanctions that Russell filed. And they say Russell has transparently, I'm not saying he's trans, but Greer has transparently sought sanctions against defendants in the amount of $2,000 because defendants have been awarded $1,500. against Greer, which Greer seeks to cancel out. And that I agree with. I talked to Hardin about this. I'm like, he just keeps on trying to cancel shit out like he thinks this is magic. And yes, this is the proper purpose for a sanctions motion. Naturally, Greer's motion is very light on heavy evidence that Greer has actually suffered $2,000 in damages, or indeed damages in any other amount. By contrast, the costs to the defendants arising from Greer's litigation continue to mount. They do. Once again, Russell Greer is right. There was a hardship in this case. Russell Greer is the hardship. Greer seeks sanctions against defendants precisely because undersigned counsel proved Greer's motion to get a continuance was factually inaccurate. Undersigned counsel can only point out that it would be a miscarriage of justice if the court were to order sanctions against the defendants arising from the plaintiff's decision to file materially false statements, meaning lie, with this court. Yes. If the defendants have to prove you're a liar, that's not their fault. They also point out the court cannot grant Greer any relief under Rule 11 because Greer failed to give the defendants any advance notice whatsoever of the motion for sanctions. Remember, you have to give 21 days notice. You have to give them 21 days notice to allow them to correct their conduct. It's the safe harbor provision. Now, and this is where I talked to them, and this is where I thought it was a great way to point this out. This is a persistent procedural error on Greer's part. As pointed out both by the defendants, its court, and itself on previous occasions. Notice 2 other times, they're like, you keep fucking this up. The defendants struggle to understand what good faith basis Greer could have for ignoring very clear requirements of Rule 11, C2, especially after his attention has been drawn to the precise language of the rule on numerous prior occasions. Meaning, you've been told multiple times, how can you not read, sir? Greer cites no Utah or 10th Circuit authority for the proposition that attorney's fees can ever be awarded to a pro se litigant who did not incur attorney's fees. And that's a very big thing. If you are pro se, you're not entitled to attorney's fees generally. I think the 11th Circuit allows pro se litigants to do that if they are an attorney, but otherwise, I don't think you're entitled really anywhere to do that. And I only know that because I've been talking to Fudbusters about his case. And he says, even assuming arguendo, meaning even for the sake of argument, that Greer could establish the defendants engaged in any sort of sanctionable conduct. So even if you could prove we have, you're not entitled to any fees. Now, with that, let's say they did engage in sanctionable conduct. They could just be sanctioned and penalized and fined. But that fine would not go to Russell Greer. The fine would be paid to the court. And Russell wouldn't want that because he'd be like, no, my whores. No, my whores. Oh. Russell Greer brings great shame on the great state of Utah. Well, the out-of-circuit authority cited by Greer appears to ignore the plain language of 28 U.S.C. 1927, but also involves different facts. Even if this court were inclined to take Greer's request at face value, a hearing would be required as a matter of due process. Yes. To establish any wrongdoing is intentionable and assess the scope of any damages. And that's true, chat. You are entitled to hearings when it comes to sanctions, especially for this type of sanction. You're entitled to a hearing. You're entitled to due process and contest it. Now, attorneys give an opportunity for oral arguments. That's enough. But there has to be something. And they say the hearings were required when intent for filings was at issue. Yeah. It says the usual method for determining what fees is for the matter to be handled by way of affidavit, but a hearing may be held in the alternative. And given with Russell, it's probably easier to have the hearing. And they say that sanctions are inappropriate, but you know what? The court should hold an evidentiary hearing if the court wishes to consider Russell's motion than outright rejecting it. Now, I know a lot of people are upset about that, saying, why would you even offer that? Because you have to. You have to. It's easier that way. So, that's how this works. You have to do that. I know people aren't happy in there. Now, from here, there were other things that got filed. And it only, chat, it only gets better. It only gets better from there. It only gets better. And this is a motion for the court to amend Order 347. Now, what's Order 347, chat, you may ask? Well, we're going to go up to here. In Order 347 in Pacer, and this is the actual Pacer file. This is the actual Pacer entries. And this is a docket text order, meaning this is an order from the court that they filed. And it talks about on February 12th, the court issued the order telling Russell he had to pay on or before March 13th. Instead, on May 20th, plaintiff filed a motion to stay, which the court denied. And ultimately, the court ordered Russell Greer to pay before June 30th. And if he failed to do so, the court would sanction him $500 more. And it says on July 1st, Russell Greer hadn't paid. Accordingly, the court ordered plaintiff to pay defendants an additional $500 for a total of $1,500. That's a lot. That's a lot for your bottom tier Nevada whores, Russell. Think about how many whores Russell could have bought for that. How many hand jobs he probably missed out on. Mr. Greer must pay the award on or before Tuesday, August 5th. All right. So that is Order 347. Russell Greer shows up and he's like, wait, I want you to amend this order, Judge. Motion for the court to amend the order. You're like, hold on, what now? I get what he's trying to do, but this doesn't make a whole lot of sense here. So, motion for the court to amend the order. You're like, all right, Russell, what are we looking at here? What's this going to be? What's it going to be, Russell? Well, you guys did a Clyde tower. Let me see if I can get him. Hey, Clyde. Come here, buddy. I hear click-clacks. Well, I hear Louie. Hi, Louie. Come here, Bubba. Come here, Louie. Hey. Look, there you go, chat. Look, he's right here. Come here, Louie. Look, Louie, right here. Oh, there you go. You saw him thrashing around. Clyde! Come here, Clyde. Come on, buddy. You gotta show him. Come here, Clyde. Hey. Come here, Clyde. Oh, hi, Bubba. Look, chat, he got a haircut today. He got his hair cut. He got a herded. And he smells, again, very nice. He does not smell like pee. He didn't smell like pee the last time around. He's been pretty good about that. But he smells pretty good, chat. Oh, smells so good, Bubba. Smells so good. Say hello. You're looking good, huh, buddy? Oh, there you go, chat. I wanted to show you he's alive. He had to take a break from making sandwiches. So, all right. So, getting on from this, Russell filed his motion. He wants a motion for the court to amend its order. And Russell says this on July 21st, his court ordered plaintiff to pay $1,500 by August 5th. There's a few things that must be said. Plaintiff did not see the court order demanding $1,000 be paid. He only saw the order denying defendant's extension to the June 10th and other filings. He says apparently 6 ECFs came through on June 10th, and he only saw the order denying the extension. Additionally, 10 other emails came through that day, thus proving the order denying reconsideration was missed. Okay, so, read your fucking emails. Oh my gosh, 6 notices plus 10 emails. Oh no, Russell. Oh no, 16 things in your inbox. Why don't you just admit I was too busy masturbating and gooning or getting hand jobs from hookers to pay attention? Just be honest about it. Just be honest about it. Clyde, I'm going to have to set you down, Bubba Bear. Hey. 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 We have to sit. Yeah, well, you know what? We'll hang on. I'll keep you going here, Clyde. We'll keep going here. So it says plaintiff did not open reply to the July 1st status report because he thought it was a duplicate status report that the defendants filed in June, to which he replied to. This is a truthful assertion since plaintiff did not see the June 10th order, thus proving, how are you thus proving that Greer thought Hardin was filing a duplicate motion, as Hardin has filed duplicate motions before. That doesn't prove anything. That's your assertion. All right, Clyde, I'm going to set you down, buddy. Okay. Good boy. Good boy. Here, you know what? Hold on. I got to give you a Clyde treat. And then it says, before the order had come in on June 10th at 2 p.m. Pacific Standard Time, plaintiff had been speaking to opposing counsel at 8 a.m. about ACH payments, but was waiting for an order from this court on the motion for reconsideration, and apparently he missed the order. If plaintiff had seen the order, he would have made payment. That's not true. You don't make the payments anyway, you deadbeat. You don't pay because you're broke. You're broke. You don't pay. Hardin never followed up nor asked for the payment. Plaintiff apologizes for the confusion. It's just a big goof, Your Honor. I'm just a big old retard. Oh, he's doing the John Coffey defense again, chat. Oh, Lord and me, oh, my. I just done try real hard, boss. My name's John Coffey, walking a green mile, boss. Can I get some of your Mrs. Okra? Your fried cornbread? He truly did not see the orders. He gets all emails on his phone and messages have gone to spam in the past. Yeah, well, you got to be careful claiming stuff goes to spam. And he requests the July 21st order to be amended in 2 ways. To reflect a due date of August 18th, as that would align better with his pay periods. So Russell gets paid, it sounds like, every 2 weeks. Okay, well, I mean, is he getting paid bi-monthly then, or how is that working? Because if he's getting paid on the 18th and you go back, like, let's say it's a 2-week pay periods. It sounds like he gets paid on the 15th. Does he get paid on the 1st and the 15th of every month? I don't know. I don't know what his pay schedule is, but if he's getting paid on the 1st and the 15th, August 1st is today. It's a Friday. The 5th is Tuesday. Like, I don't see... and if it's pay periods, chat, I mean, none of these... we need a calendar here. Just so you can understand my logic here for Russell. And you can come along with me on this, chat. You can, here's my logic for Russell. Here's my logic for the boy. Let's give it to the boy, okay? So if he's saying I want to pay on the 18th, okay, and this is the original due date, okay, it was the 5th. All right, he says I want to pay on this day instead. Move it to this day. That'll work better with my payments. Well, nobody gets paid on Mondays, so I don't think he's getting paid on Mondays. People get paid on Fridays, or people get paid like the 1st and the 15th of the month. That's a very common way of doing it. So let's say that happens. Well, if Russell gets paid on the 1st and the 15th, he can make the argument I get paid on the 15th, so that way I can pay you on the 18th. Okay, that kind of makes sense. The problem is I get paid on the 1st, just pay on the 5th. So this doesn't make a whole lot of sense there, Russell. This doesn't make a whole lot of sense. I don't know why he's doing that. Yeah, 51 says, I get paid the 15th and the last day of the month. Yeah, that happens. Yes, rent is due on the 1st. I get that too. But, I don't know what Russell's rent is. Maybe he's still living out of his car. Who knows? We don't know. He hasn't provided that information. And I think Hardin should make him show cause for a debtor's exam. Like, why do we have to play this game? Show us why this works. But moving back to this, Russell says he can't get $1,500 by August 5th. Since plaintiff didn't see the June order denying the motion, plaintiff would sincerely ask for a payment to be that of the original $1,000. He will promptly pay that no later than August 18th via ACH to Hardin. And then he cries again and says defendants have still not paid the appeal award, and so this alteration should be fair. Respectfully submitted, Russell Greer. And there you go. Now, Russell Greer attached 2 exhibits. His exhibit A was many emails received. Many emails. It's awful. I mean, I've had days where I've received like 60, 75 emails, and that's not even that many. I remember as a prosecutor one time, I received like 150 emails about like a bunch of things all at once. It took forever to like read through it and get my day going. But yes, many emails, many. It's too much, chat. It's many. It's too much. And yes, Hardin did agree to the offset, but Russell's saying it, I'm paying the 1,000. He's like, there's many emails. Help me. Help me. So he got a notice from the courts. Russell and Matthew, that means Hardin, talking about electronic payments. Rentalcover.com. What the fuck is that for? Your rental cover quote is ready. Wait, you can rent covers now? Oh no, chat. Nick is franchised. Oh no, chat. Okay, so rentalcover.com is a worldwide rental car protection. So where are you going, Russell, that you need a rental car? Where are you going? Where are you going? Unless you're renting a car right now, which is kind of like about that. So, I don't know how that works, Russell. So it's gonna be on you, buddy. Yeah, Nick timeshares Kayla. Ah! He's still renting from Uber or Lyft, very likely. Yeah, so he's oh god, imagine him being your Uber driver when people get drunk at night in Las Vegas. I'm surprised he doesn't get fucked with. What was that out there? Okay. Yes, gooning ain't easy, but it's honest work. Yes, it is. Yeah, I thought she was our wife. Well, she's everyone's wife now. But look, court notice. Aw. Court notice. Like he's including the New York Sun. He got a bullshit fucking like kind of spam like just news email. Okay. Russell Greer response to that sport. Oh, my email update from the Blaze. Yes, because Glenn Beck, buy gold and khakis. Yeah, it's so hard, Russell. It's so hard, buddy. So hard. It's so hard. It's the big pun defense, chat. It's so hard. Then this is Exhibit B where he's talking to Hardin. And he says, on June 10th, I can use an e-bank for my checking account, but I can send wires for that, I believe. You're like, okay, yeah, that's all right. Okay. So I don't know what you think this is going to do for you, Russell, but okay. I mean, yeah, whatever. Then Matthew Hardin does this, and this is I wasn't aware he was going to do this, but this was beautiful when I learned about this. And Chad, I'm sorry. The past week somebody was telling me and I couldn't stop from reading the thread. It's just been amazing. Matthew Hardin comes in with a fucking nuke here. It's a motion to revoke plaintiff's access to the electronic filing and system and service. So the ECF. And they want to revoke the plaintiff's access to electronic filing and service of documents. And they point out that the Northern District of Florida denied Russell access to filing before this case was transferred back to Utah, consistent with the ordinary procedures that electronic filing is unavailable to any non-attorney. Yes. And it said Russell Greer called Florida clerks, and you guys remember this, he called them really rude and snarky for insisting documents get sent by the mail. Really rude and snarky. That court's orders sent via mail were returned as undeliverable. Remember, Russell has a problem. He won't show his address. He files bullshit addresses because he's going to get stalked. The Tiwi farms are domain. So he wanted to provide a valid address. And Russell's continually filed inaccurate physical or mailing addresses with every court with which his case has been pending. Now, they point out that as they stated, and getting into this as Hardin goes here, as stated on the record at the hearing in November, Russell is prone to claim he does not receive emails. Similarly, the defendants have explained to the court that Russell Greer pops off at the mouth with a pen and files untrue or unresearched motions because it's easier for him to do so using electronic filing than it is for him to verify statements he has made about the court's own records and orders. And it says the Greer has now confirmed and amplified the well-documented fears that Russell does not keep up with his emails, including both emails from the court and from undersigned counsel, which are necessary for managing the case. Greer openly states he did not see the court's order. Greer's vision impairment is conveniently intermittent because Russell Greer states that he did see another order which denied a defense motion. And it says, however, Russell confesses he did not open another email because he assumed the contents of that email made opening and reading it were unnecessary. Thus, it appears Russell sees emails which he believes are helpful and doesn't see or ignores emails which are unhelpful. And Greer posits two contradictory explanations for his woes. First, he states that he gets all the emails on his phone and messages have gone to spam in the past. But Russell also indicates he did in fact receive 10 emails, including the relevant emails he claims he did not see. The pertinent emails did not go to spam. Russell simply ignored them. Oof. Oof. The defendants cannot litigate this case if Russell is permitted to continually claim he does not receive pertinent filings. And that's true. There's no way we could resolve it if every time Russell goes, I never got it. I never got it. I never got it. Additionally, it appears Russell is abusing the ability to use the ECF to file false and unresearched motions, which the defendants must respond. Accordingly, they want his filing access to be revoked. And I think that's a very good sanction here. They want Russell to send and require plaintiff to file all documents in a paper format as usual. That's going to make it tougher for Russell. And remember, Russell doesn't like doing work, so the tougher you make it, the less he's going to do, which will get him into more trouble. Similarly, the defendants stand ready to serve Greer all documents in paper form as soon as Russell files a valid service address with this court. The defendants reiterate that every address Russell has filed to date has resulted in return mail, possibly because Greer has continually filed all pleadings using false or incorrect addresses at which he does not reside, because he, once again, is scared of the Tiwi farms. And Matthew Hardin from the Hardin Law Office, yes, their new executive vice president of furry outreach. They started a new outreach at the Hardin Law Office. Now they're working to reach out into the furry community. And Matthew Hardin is really pushing that. He mentioned that, and I'm like, do you really? He's like, those furries, they're just heckin' good folks. They're just heckin' trying to have a heckin' good time. And I'm like, I don't know if that's really the right way to look at this, Matthew, but he's like, I do, Sean, I do. I'm like, all right. So now there is also another thing that Hardin filed right after that yesterday. And it is a opposition to Russell's motion about amending the court order regarding his penalties and sanctions that he owes now. And this one here is just beautiful. I love it. So Russell states no good cause for relief from the multiple orders arising from Russell's litigation misconduct. And they say, notwithstanding that motions for sanctions are currently pending, defendants note the court has only awarded sanctions once, The reason there are multiple orders is that Russell's repeatedly defied this court's orders rather than complying. And notice, that's the only thing that's happened here. If we finish early, will we get a model stream? Of course. Of course. We're almost done, chat. We've got like 2 things, and we'll be done. Instead, Greer states he did not see one order and ignored another without bothering to open it. Unsurprisingly, when Greer ignores emails from counsel in the court, decisions are made without his participation. That is not an error in need of correction. It is a case of Greer making his bed and now lying in it. Now, guess what's going to happen? Russell's going to use this quote next. The next filing Russell does, that's going to pop in their chat. I'm telling you right now. I'm telling you that right now. So, plaintiff must now lie in his bed because it's too late to remake it now. Says, what's more, Russell has a pattern of ignoring court orders and filings and later claiming there's good cause to set aside those orders. And this is where, Hardin, my hat is off to you, man, for finding this shit. Beautiful work. In Humboldt County District Court, Nevada, Greer recently made a remarkably similar argument to that which he's making now. Exhibit A. Oh! Uh-oh. Uh-oh. Specifically, Greer claimed in Nevada that he did not respond to a defensive filing in a timely manner because he only checks his mail twice a month. What? What? And even when he receives the mail, he does not read it immediately because of his hectic work schedule. But guys, I got the mail, but I was too busy giving blowjobs at the truck stop. I couldn't read it. Like, what is so hard, Russell? What is so hard? I bet the real issue is he, like, wipes up the drool and everything's smeared and he can't read it anymore. Yeah. It's a hectic work. Russell's driving. That's it, chat. We figured it out. Russell is working for Nick. He's driving Nick's kids everywhere. That's what's happening. There is a crossover after all. Whoa. It all makes sense now. So, unsurprisingly, the Nevada court found no grounds to grant Russell any relief. The facts here are not any different and are certainly not any favorable. But it gets worse. Russell's latest motion is the latest in a series of motions that appear to be materially false. Specifically, Russell claims that he needs an extension of time to pay awarded sanctions and that he's unable to pay $1,500 by August 5th. They say even if it's true, it is at best arguable whether Greer's professed inability is a defense. Greer never raised the ability to pay as a defense before the sanctions were awarded. Such Greer's decision to only raise it when attempts are made to collect is curious. Moreover, the awarded sanctions did not fully compensate the defense for the costs they had incurred, in part because the court noted that Russell Greer's former status was as an IFP. In form of pauperis, Russell was poor. In any event, the ability to pay a sanction is not necessarily dispositive, even if it is properly raised. The ability to pay is only one factor of many which a court must consider. They say as recently as May 22nd, Greer claimed he had over $5,000 in savings, such that even a much larger sanction would only wipe out most of Greer's cash on hand. It's difficult to understand why Greer had over $5,000 in May. Remember, that's his business money. That's his business money, chat. Which he'd have to pay $1,000 of sanctions. But Greer is suddenly unable to pay for his own misconduct. And it says the underlying litigation misconduct for which the defendants were awarded sanctions took place in the fall of 2024. The show cause order led to an award of sanctions against Greer in docket number 189. Was issued 162 docket entries ago. 162 docket entries, chat. Remember, where are we up to now? We are up to 351. The case continues to age, but Greer's recalcitrance continues. Ooh. Ooh. But yes, several months have elapsed, and he's only being asked to pay less than a third of the amount he stated was on hand and available. Oh. Whoa. Yeah. Now, here's where this is the exhibit that Hardin filed. This is just this is just Hardin. I appreciate and I have a respect for Hardin getting I know the farms has helped at times, like get stuff too, but Hardin's ability to go dig stuff up, I really respect. I appreciate this as a professional. From player to player, pimp to pimp. So this is Russell Greer versus Lance Gilman. And this is going to go along with that other case that's out there. I think Useful Mistake wanted me to cover. I think, is this it? Or is this a different one? There's one or two of these cases he wanted me to look at here. Anyway, this is a order denying plaintiff's emergency motion for extension of time to file an opposition reply. And in this, there was a motion to dismiss that was filed in November 30th of 2022. Said motion was served on plaintiff Russell Greer and his proper person via U.S. mail on November 28th. The plaintiff failed to file a timely response. This matter was submitted to the court on December 20th. Russell had 14 days after service to respond. On December 21st, the plaintiff filed an emergency motion for extension of time, and the court is uncertain why this emergency motion was served on defendants, as there is no date of service indicated on the certificate. And that's kind of critical. So he's already got service problems. The plaintiff's emergency motion for extension of time. It says, nevertheless, the defendants filed an opposition on January 9th, which is timely, assuming that he mailed his stuff on December 21st. And they said allowing 3 additional days when they must act within a time certain by mail. The defendant served this opposition on January 6th. Plaintiff did not file a reply as permitted. On January 5th, plaintiff filed an emergency amended motion to extend time and request to submit. In the amended motion, Russell admits that he only checks his mail twice a month, and that Russell only checked his mail at the beginning of December and had no mail, and checked his mail again on December 12th to find the motion to dismiss. Once again, that is the dumbest fucking thing I've ever heard of. I've never... this makes no damn sense. And that plaintiff did not immediately read defendant's motion due to working 60 hours a week. Okay, what? So, what the fuck? So what? And 4, that plaintiff was confused when he should reply since the mail was postmarked November 30th, but he did not receive the motion to dismiss until December 12th. Well, that you didn't receive it then. Like, plaintiff's amended motion, and see, that's the problem. If you don't check every day, we don't know. So the court can extend time to file for good cause after time has expired. Courts always have that authority because of excusable neglect. To establish a neglect, you must show you acted in good faith, you exercise due diligence, there's a reasonable basis for not complying, and 4, the non-moving party won't suffer. Here he fails to show it. He doesn't meet prong 1, and 2, because he did not act in good faith and did not exercise due diligence. Russell openly admits he does not diligently check his mail despite ongoing litigation with specific time requirements, because doing so would be inconvenient. Like, yeah, because it gets in the way of all the dick sucking. Plaintiff further admits that he did not even read the motion dismissed after receiving it on or about the 12th because he works 60 hours a week. Russell did not, like, and that's the thing. It's like, well, what are you doing in your 12 hours when you're not working, Russell? He'll be like, I'm gooning. I'm working on my business. Russell did not file his original emergency motion approximately 9 days after receiving the motion. None of these actions are consistent with the litigant who acts in good faith and with due diligence. If it really was an emergency, Why isn't it getting filed December 13th? And they say next he fails to meet prong 3 because he doesn't present a reasonable basis for not complying. Now they say, well, district courts should assist pro se litigants as much as possible. If this is in bold, chat, this is so dumb fucking read. A pro se litigant cannot use his alleged ignorance as a shield to protect you from the consequences of failing to comply with basic requirements. And it says the court finds any argument regarding any confusion to respond unpersuasive. Unlike the pro se litigant in Rodriguez, Russell here has filed previous motions without the assistance of counsel and is capable of filing motions on his own. Plaintiff is also not a typical pro se party. He is a paralegal. And they point out that they show other things he's done. He often cites to pertinent statutory and case law and motion practice and appears capable of interpreting and applying the case law to this case. Ultimately, Russell cannot use his alleged ignorance of DCR 13 and the Nevada civil rules to protect himself from the consequences of failing to comply. And this, although Russell wasn't sure of the filing requirements, Russell provides no evidence he acted expeditiously after receiving the motion. Well, and if you're not sure, call the court. What is the time frame? What is it? Did you reach? No, I'm retired. Or that he took any action to comply with the requirements. Instead, he admits he did not check his mail despite ongoing litigation because traveling to the post office on the busy street isn't exactly easy. Plus, he has to take time out of his day to go. Aw, Paul Wassel. And he did not read the motion because he had to work. That's not excusable neglect. And checking your mail and not having time to go. The fact that going to the post office is inconvenient or having a demanding job are not reasonable bases for noncompliance. And you know what you could do better, Russell? Have your fucking mail delivered to your apartment. But you know what? The Kiwi Farms would find it. So, suffer, Russell, suffer. So, Russell blames this with timing requirements and the lack of e-filing. And the court finds this baseless. The legal system has historically and adequately functioned off physical mail. True. And e-filing is a luxury, not a necessity to comply with time for filing requirements. Yes. And not everywhere in America, chat, still has e-filing. Many places don't, especially in rural areas. Like a lot of the counties I practice in, there is no e-filing. Everything is done normally. You either file it, you can fax file some places, but some places you can't. Some places you either mail file or you file in person. Those are the two options, in person or mail. The law even contemplates the additional 3 days. And considerably, Russell could have consented in writing to accept service of all pleadings via other means, email, and he could have done that. Russell could have agreed to it already, as it existed in the rules, and you are allowed to do that, chat. There are times where you could just say, hey, I'll accept stuff via email. And it says, lastly, we're not going to address number 4 because he's failed to meet everything else. See here, and it talks about how to do pleadings and filings and service. In general, a paper service is served under this rule by delivering it to any person consented to in writing, in which event service is complete when the person making service delivers it to the agency designated to make delivery. And you can do it. You can consent to different things. So what happened to Russell? Denied. That's it, Russell. Suffer. So, now here's what happened in the aftermath of that chat. The court, the court cucked. Russell was able to punk the court. Because we have this docket order. A order granting in part and denying in part the motion to amend incorrect. In his motion, Russell explains he did not timely pay the sanction award because he did not see the court's order. And he says that along with the other emails. Plaintiff further stated he did not open the July 1st status report despite seeing it because he thought it was a duplicate of the June filing. Plaintiff has a responsibility to read court filings. Yes, he does. Not seeing an order and ignoring another filing does not constitute good cause to reduce the sanction amount. So far, so good. Okay, we're not amending the sanction amount. Notwithstanding that, plaintiff represents that an extension of the 18th aligns with his pay period, and he would be unable to get to the 1,500 by the 5th. Bullshit. As such, the court will grant one final extension. You're cocked! You let him punk you, Judge. The plaintiff is ordered to pay the $1,500 sanction on or before August 18, 2025. So, yes, partially suffer, but not really. As the court stated in its previous order, failure to do so will result in the court entering a show cause requiring Russell to demonstrate whether this action should not be dismissed. Signed by Judge David Barlow. You ain't got no balls, Judge. You ain't got no balls. Yes. One final sanction. Oh, buddy, we're steamed up. Don't you do it again. We really mean it. We really mean it. Don't do it again, Russell. The red on black text intent. Well, yeah, it's done that way. These orders like this, even if you go to light mode, these appear in black and this is still red. It's so that it's clear this is done. That's done intentionally. Red orders doing look, there's a couple times there's red orders here. And it's so the parties can see it and they can't claim, oh, I didn't see what happened here. Like there's generally when you're denying things, that's how that works, or a very critical order. You also see things in other colors, like, purple every once in a while. But yeah, seeing a lot of red here. Ooh, you don't normally see a lot of red in a case like these cases. But also remember, this case is up to number 353. So, yeah, chat. This is getting there. One final extension after 5 more. Yes. But it's still, guys. Yeah. It's still. Yeah, I'm colorblind, Your Honor. I couldn't see it. It was gone. It disappeared. That would be hilarious. So, all right, guys, we are on to the last thing. Russell filed a response today. Today, chat. Today. About the revocation of ECF access. Filed August 1st. Ooh, it's hot off the press, chat. It's hot off the press. And guys, some of you asked questions. We're going to get those in a second. Russell responds and says the following. In a long line of frivolous motions meant to delay resolution of the case, defendants file a motion on 7/31 requesting Russell lose electronic filing access. Also, this kind of defeats Russell's bullshit of I don't pay attention, because Matthew Harden files it on 7/31 and immediately Russell responds. Like, this kind of defeats your argument. You're paying attention when you want to. The standard for filing restrictions in the 10th Circuit is looking at whether the pro se litigant is engaged in abusive conduct. Well, you have. The defendants claim that plaintiff contradicted himself and claim he lied in his motion to amend, thus warranting a denial of e-filing. However, the defendants made a bare and broad accusation. Yeah, well, it's a pretty effective one. Pretty credible. Plaintiff clearly showed through exhibits that he received many emails that day. Okay. Defendants didn't articulate how exactly plaintiff allegedly lied. Are defendants claiming plaintiff lied because all the emails were read? If so, they're clearly misunderstanding plaintiff's motion. Yes, it's you who is retarded. Plaintiff had missed the 610 order, the June 10th order. He had to go through his email and do the all mail search to find every message received in the past 90 days, whether those messages were read, archived, etc. He looked for the 610 order because he was confused. He was very confused, chat, about there being a reference to a June 10th order. As demonstrating that same motion, Russell had been inquiring about a method of ACH payment. Plaintiff was waiting on the order before paying. The defendants never contacted plaintiff to follow up to discuss payment, thus proving plaintiff had no knowledge of the June 10th order. Defendants have done nothing to discredit that assertion. Yeah, okay, Russell. Further, no filings from Russell have been abusive, as defined under the Verner standard. Nor has plaintiff been warned about filings. He was only warned about a payment, to which, again, he never saw the order. The warning never said he would use email filing rights. Revoking privileges because of a few missed emails would be quite extreme, and there would be no 10th Circuit basis for that, as this court seems to heavily rely on precedent. Additionally, revocation would be arbitrary. The defendants have been the ones engaging in overburdening this docket with abusive filings. Once again, it is you who are abusive. Yet this court refuses to sanction or even admonish the attorney who should know better. If pro se litigants are held to the same standard as attorneys, then what standard is this court adhering to? Well, this is deep tread fucking lightly, Russell. Because plaintiff respectfully sees an arbitrary standard where he's the only one being punished. Yet Mr. Matthew, he's like a little kid. Hello, Mr. Matthew. Has Doc stalked, harassed, and threatened published sensitive information about plaintiff and those close to him, yet nothing's being done about that. This is really dangerous, Russell. You are. Ooh, you are brave behind emotion, buddy. God, you would not have the balls to say this in front of the judge. I would fucking pay to see that. Russell, if you do that, I will send you $100. That way you can get a free blowjob on me. Say this shit on the record, and I will fucking send you $100. The Winnemucca fishing expedition should have brought the full force of this court on defendants, but nothing has happened. Oh, buddy. If plaintiff loses these privileges, then that would indeed be arbitrary. Oh. Well, I'm not. No, Shadow Shale. I'm not saying he needs to give me a blowjob for $100. I'm saying I'll give him $100 so he can go get a blowjob from a hooker. Oh. He shouldn't be doing this. Lastly, losing privileges would be an undue burden because having to mail 10 to 20 pages through FedEx, you don't have to do it through FedEx, but that you can use the mail. Every time a motion or response is required is costly and time-consuming. Respectfully submitted, Russell Greer. And that's it, chat. We are all caught up. We're all caught up. Oh, Russell. And yes, Celialism is correct. Nothing is going to happen. Russell has just called out the court for being faggots. And the court's going to go, yes, you might be right, Mr. Greer. After all, Saw. And they're just going to let him do it. They're just going to let him do it. Sadly, that is what's going to happen. I don't know what to tell you there. Yes, Sean, they charge more because he drools more than they do. Yes, Russell ain't hiring $100 hookers. He can get 20 for $100. Well, then whatever he wants, let him do it. It's his money. It'll be his money. Yes, the Greer is telling the judge to his face that he should let him ignore his decisions. Yes, I agree. They are. That's actually very strong words. Those are strong words to put into motion. Like, he's a braver man than me because I would be very careful about how I phrase that. That is, ooh, he's braver or dumber, maybe both. So, Robin Hood says, "Do you think Russell uses a rubber keyboard to keep the drool from building up?" No, no. He uses, and I remember my library had these back in the day. There were those big, like, vinyl rubber clear things that covered up the keyboards. Um, they were just obnoxious. I'm sure that's what he uses so he can type. So most of the $100 will go to the Olive Garden dinner. Yes, very true, very true. Ryu Planeswalker says $100. That'll be enough for 20 cans at Stoney's. Oh, that would be fun. That would be fun, chat. BKS is saying I hated those keyboard condoms. Yeah. No, they were very interesting. They were interesting. Let me see if I could find one. See if I can find the old ones. I mean, like, they have rubber ones now, the vinyl or like, yeah. Um the old ones. Like, they had really old ones and like the whole keyboard would like basically sleeved into it. Now I can't find the old ones anymore. Oh well. Oh well, that sucks. I'd show you guys a trip down memory lane. Let's see here. Nope. 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 They weren't silicon because I mean there was, like 30 years ago, so they would have. Yeah. Nope. Don't see it. Yeah, the old one. It's all new stuff now. Can't find it. Can't find it. Don't care that much anymore. Um, yeah, the yellow ice rubber. I remember that too, man. Oh wow, taking me back. Taking me back. So yes, Russell got to punk the courts, and the court's not going to do anything about it. So, oh, David's saying on the Stebbins v. Jones case that Jones may not approve the dismissal. Ooh, I'll have to take a look at that. I have not caught up on the Acer Thorn stuff. I need to get caught up. So, let's see here. EDW Raptor for $5 says beard oil is better than beard cream. It keeps nice and smells great. Kara says weird how those earthquakes happen near the Russian nuclear submarine port. Yeah, the earthquake on the Kamchatka Peninsula and the volcano eruption happened very close to the what's known as the Hornet's Nest. It's a Russian nuclear missile submarine and hunter-killer submarine base over on the Kamchatka Peninsula. It's actually kind of neat. I think it's called like Rybaki or Rybaki, I think is how you pronounce it. It's very interesting. It is. Morse Apple 556 says Reddit doesn't have a watermark. You can't use it. That'd be so funny if they try to make that argument. Morse Apple says, also just got home from a long day / week of work. Hope your week went better than mine, Sean. Well, I'm sorry your week didn't go that well. It's always next week, but hopefully you have a good weekend in the meantime. But thank you for the super chat. And yeah, well, I mean, it went okay. We were set for trial Monday, and we ended up playing out today. We played a little bit of chicken, and my guy, against my advice, my guy played a little bit of chicken, and I think he kind of pulled one out here at the last minute. So, it worked out this time. I never recommend it, but it kind of worked out. So we got what we were looking for. So it all works out, I guess. And he's happy with it, as you can be. So, Whiskey 77, part of Assholes React. Guys, see him. A-Holes React every Sunday at 9 p.m. Says here, ag biochemist makes AI nudes of Frogan. Ugh. No, thank you. Stephen Cooper saying, as much as I appreciate Generalissimo's ideas, Mexico had a more efficient system, C-130s for the win. That wasn't Mexico. That was Uruguay. would take people, what they would do with their communists back in the Cold Wars. They'd put them in C-130s and kick them out over the Southern Atlantic, out the back door. Yes. That was a very common way they disposed of things. Might have also been Paraguay as well, but I know Uruguay did that. Jefferson Post, could service between councils be stipulated? Yes. Council could say, yeah, just start emailing me shit. That's good enough. Yep. 100% you can do that. Franklin says, yeah, going back to the Frogan thing, they could change their hours to avoid service. But remember, let's say it's somebody who works third shift. You might have to be up to catch him at third shift. But the guy goes out there at night to figure out what he can do. Like, it's clear he was doing reconnaissance, trying to figure stuff out. Because if he just went up to the door blindly, Frogan won't answer. Now she knows she's being hunted by a service processor, and now she's in the wind. So that's why he did that. Chugi Show is saying for $4.99. So he knows the Hannah Montana song by heart, but didn't think beard oil was a real thing. Well, I mean, yeah, so I don't like what you're implying. EDW Raptor says, I whisper into Sean's ear, sir, the second dildo has hit the court. MLS, make it a lot simple. Hi, David, friend of the show. Guys, you can find him over at MLS, home of the Lego streams. Says, Russell is a brilliant man. We all have to have our idols, and I guess this is David's. And David is saying, technically, I don't think he has electronic filing, but email to the clerk. But he does obviously get and ignore email service. Are you talking about Russell or Stabby? Zero MSS is saying, how is Harden reaching out with a 338 Lapua? I mean, that counts. Hey, that's reaching out a couple hundred grains at a time. Patrick says, I wouldn't say rich as much as they have jobs and put all their money into their kink. Yes. Their costumes are expensive as hell. Varlo is saying, how long before Russell tries to fake his own death and blame it on the farms in order to make this all go away? Very good question. I'm assuming that's going to happen very soon. Very good question. Joe Schmo says, can judges order a payment plan for sanctions? I mean, they can do kind of whatever they want for their sanctions. They can structure it however. Now, ideally, when it comes to these sanctions, what should happen is Russell should contact the party who is being forced to pay money. Russell should contact Harden, and they have another meet and confer and say, look, I owe you $1,500. I can't pay that right away. I can pay you $500 now. I can pay you $500 in 2 weeks, and I can pay you $500 in 2 weeks after that. Now, I've been in that situation where the, pro se party, we had to get filing fees or attorney's fees because I had to file motions to deal with it. And I talked to my client and say, I want to do this. I think that's fair. I get it. It's your husband or it's your wife or it's the party we're suing. Hey, can I, this is what I want to do. And I'll say, sure. That's where it's and then you put a status report together for the court and say, Your Honor, we met and conferred. The defendant is going to pay. They are paying on a payment plan that will be proposed as this. If there is a breach of this payment schedule, we will notify the court immediately. But yeah, you can work it out however you want to. You can work that stuff out. Court would appreciate you working things out. Let's see here. I wish I had money or a kink. So, are we modeling tonight? Yes, we are. We're going to keep working on the M1, the 155 millimeter howitzer. We're getting pretty close, chat, to getting it all put together, all the assemblies. So we're going to work on that here. We're getting to the good parts. We're getting to the good parts, chat. Are we going all night? Not all night, but we'll go for a little while and do some modeling. So, and that is going to be, hold on here. I'm going to set that up real quick. But chat, we are all caught up for tonight. this Russell stuff, I mean, I don't know what it's going to ultimately do. Um, I don't know what's going to happen, but at the end of the day, Frogan and them, oh God, things are going from bad to worse. And unlike Legal Mindset, you can actually hear me when I talk about what Frogan's troubles are. Alpha Mindset. I saw that Andrew put that out there, and it's like it's him on mute, and I'm like, oh no, oh no, oh that sucks. Hopefully he gets that fixed. Did you end up getting a strike for bullying Cody Wilson? No, what? Hold on, what are you talking about? Did I get one recently or something? No, it's because I think that was I think there was because of the I I don't I think there was something else there. I'm not 100% sure. But at this point I don't really care. He's just a bitch. So I wouldn't get too worried about it. But let me just double check here. You guys make it sound like I just got it. So um Oh no, one of my Alyssa Mercanti JT Smash JT videos got taken down. Wow. Somebody fucking flagged me for reading an email. Fucking cunts. Fucking cunts. The last Fudbuster stream you did got removed for bullying. Didn't know until someone trying to watch the video I linked months ago. Hold on. What now? I didn't realize I got. All right. I'll hold on here. No, we're gonna take a look at this. Okay. Let's see here. Content. Um, the ethics complaint one got removed, but that was from a while back. So part of it, no, but everything else is up, I think. The last time I talked about something was in March. So yeah, I think so. Well, I don't get email notifications. I just get things in my YouTube thing. Debbie says, you set up the model stream for the right date. I don't know. Did I not? Oh, hold on. Let me fix that. Damn it. I hate this streamer needs to set it up for the date you're on. It's so frustrating. All right, chat. Well, that is it for us tonight. We are done. We are moving along. Yeah, thank you all for being here. Debbie, thank you for pointing that out. I didn't have that set up right. You guys, we're gonna head over to the model stream and start working on that. So as always, until next time, chat, just because you did it does not mean you're guilty. Although, Frogan, you're gonna default and Ethan's gonna own your soul. So have fun with that. Have fun with that. Stuff. It's gonna be beautiful. Good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that hated you?